I'm looking at Amanda and Laura in particular. You're gonna help me make this interactive today.
No pressure.
And if I can get it to pull itself up in a little bit, I will continue to try to do so. So my task today was to talk to everybody about testimony, deposition, and subpoenas. And so let's kind of get a gauge of where everybody is right now. How many people have ever testified in court? You can put press the little hand button if their camera's turned off. Jerry, are you looking to say yes? Amanda, Jerry. Okay. How many people, oh, Jason, how many people are terrified that someday they may have to testify in court? Jerry, you've already done it. Why are you, no need to be scared now? Oh, there we go.
Part of the reason I'm terrified is because I've done it.
Oh no. Oh no. Okay. Thank you everyone for your hand raises. Yes, I imagine that's why a lot of you may be here today, is that you're nervous about what it would mean to have some interaction with the court system. And so we're going to talk about the different kinds of testimony, some tips about testimony. First, I'd like to hear about the context in which people have testified before. Jerry, would you mind starting us off?
I was afraid that was going to happen.
You can tell me no, that's okay.
No, it's fine. It's not been recent, but I do primarily primary care now, but the in court was usually for extended stay for psychiatric patients about whether they were safe or not. And so I guess I'll leave it at that and see what follow-up questions there might be. But
sure. So were these usually mental hygiene hearings?
Yes, they were. Is this patient suicidal? Are they at risk of harm to others? Those were particularly the challenging ones when I was doing it more. It seemed like, question of, not that the individual themselves are not important, but when there was a question of possible harm to others, that seemed to, at least for me personally, raise the bar of angst.
And then Amanda or Jason, would either of you care to share your experiences testifying?
Yeah, on one occasion, I simply served as a fact witness.
Perfect.
And then I think after that, the prosecution had called me in to justify a diagnosis that I had made for psychological evaluation to essentially support their case. That was it.
So still, were you qualified as an expert in the second case?
Yeah, they ended up qualifying me as an expert.
In just psychology in general?
Yeah.
Okay.
Yeah.
So Jason brought up a couple of points, so a couple of good terms that may be foreign to people. The first thing he said was a fact witness. So if we go into testimony, there's different types of witnesses. You can be a fact witness or you can be an expert witness. Sounds like Jason has done both. I've actually never been a fact witness myself, but many of you, should you get called to court, may be in this role as a fact witness. A fact witness is a person who has information about things that they've experienced with their senses, seen, heard, felt, physically felt. I guess smell and taste would be the other ones, although less likely, but maybe you smelled a strange smell involved in a legal case. And so the role that many of you would play as a medical or mental health provider could be a fact witness. So for example, maybe you're doing therapy with an individual and they get involved in, I don't know, maybe there's a child neglect case opened. And maybe you're called to court just to talk about how long you've been seeing them for therapy, what are their diagnoses. Jason's example was a little bit different than, a little unusual, but oftentimes if you're the provider for the individual, That means you're not testifying as an expert witness. You're testifying as a fact witness. You're telling them what you have observed in therapy services. So, and that's where your testimony stops. If you are not qualified as an expert in this case, then you would not be able to give an opinion. Now, your diagnosis is based on symptoms that you observed or were told about. And so I think that falls under that, like facts and observations. But you would not be there to give an opinion. So when they say, okay, so Mr. Smith, you've been seeing Mr. Smith for 2 years for individual therapy. Does Mr. Smith have the requisite capacity to be a parent? As your role as that therapist, you don't have to, you can't answer that. You have not been qualified as an expert to give that opinion. You can simply state that these are the therapy services, this is what we've provided. In contrast to that, we have expert witnesses. Expert witnesses is when, based upon knowledge, training, and experience, a person is qualified to give an opinion in court because their specialized knowledge and training and experience is over and above what the court would be expected to know themselves. And so this is where my work usually comes into play. I'm often called to testify in court about an individual's, say, competency to stand trial. So I've conducted an independent evaluation of this individual. I'm qualified as an expert when I get into court, and then I'm able to give that psycho-legal opinion to the court. Jason, did you have something to add? I saw you come back on the screen.
Yeah, I mean, I'm actually glad that you're bringing this up because I'm dealing with a situation right now where I have started seeing a 7-year-old girl for therapy, and I saw her one time, and the adoption worker and DHHR worker had actually asked me to provide an opinion on whether or not visitation with the child's biological mother is appropriate. And I've upset some people by saying, I'm sorry, I can't offer, such an opinion because, that's me entering into a dual role. So I had to, write a pretty lengthy letter to several people explaining the position, citing the APA ethics, but they weren't happy. So I'm glad that you're bringing this up. Yeah,
that can definitely. Kayla said that happens, comes up all the time for her too. Kayla, can you remind me of the context?
I'm a therapist, so I work with kids. So I do a lot of foster families and adoptive families. And sorry, my camera is just like on the fritz today. So I do a lot of that, and I get a lot of like social workers and caseworkers being like, hey, we want to do visitation. And I'm like, I don't feel qualified to make that decision for the kid. I try to like keep them at arm's length as possible.
Yeah, it's really interesting. It also brings up the point that a lot of people will ask, even the courts often ask inappropriate questions of us, and we as providers need to know our limits. We need to know our competence. We need to know kind of that line that we won't cross, and we have to be pretty confident and assertive in our response to them. Sounds like that's what Jason's been experiencing, because they're not immersed in the same world that we are. Now, I think the visitation question is really interesting because I was kind of thinking about it on two sides. They want to know if the mom can have visitation, well, then someone needs to evaluate mom, I imagine. And there's that dual role that Jason's talking about. You can't be the provider for the child and then also be an independent evaluator for the parent. You also can't be the therapist for the child and the evaluator of the child. Now, you can go the other way if you're very careful. You could do an evaluation of the child and then take them on for therapy, but you can't go back to that evaluator position. And so one thought I had, if there was a lot of pushback on this visitation issue, would be you could speak as a fact witness about the child's mental health symptoms, and you could say I imagine if you knew, well, they had visitation, I was told they had visitation on this date, I saw the child on this date, these were their symptoms. Leave it at that, right? It's not completely helpful to them, but it does give something. But again, you're sticking to what I saw. What I saw was how the child looked on this date after visitation was on this date. And again, I know DHHR tries to find good evaluators, and they have a hard time being able to find people to do those evaluations, especially in more of the rural areas. But those are wonderful examples. Jason, I feel like there was another topic you brought up that for us to talk about. I'll think about it and I'll get back. Amanda, did you have anything you wanted to add about your experiences testifying?
No, this is really helpful. I've testified a little bit over a dozen times, and so I've testified as an expert witness, and then I've also testified as a fact witness, which I didn't know that that's what that was called, but now I know. Yeah, and I think it's really helpful. I love how you clarified the dual roles, because I think that we do get pulled into inappropriate discussions, and unfortunately by judges at times. Like my last time, I tried to object and he yelled at me and said I can't object, but
That's awesome.
I was like, this is, well, so it was a custody. The dad was going for increased visitation, and both great parents, and the judge pretty much wanted me to lay out what the visitation should look like. And I told them that was not my responsibility. And they went in, they wanted to go into other topics of like what she had said about her stepmom in certain sessions. And I was like, this is really inappropriate and has nothing to do with anything we're talking about. The judge was like, you can't object. You have to provide that information. I was like, I don't recall that session.
That was a great response. Yeah,
well, not really.
That's where you stare at the attorney who's called you and you just stare at them until they stand up. I object, Your Honor.
Oh, so not really, because but he made me go through my paperwork because I was doing it by phone. The attorney was there and I was texting her the whole time. I was like, you have to stop this. It's like, this is inappropriate. Both mom and stepmom are in the courtroom. Like this is going to ruin my relationship with her and impact theirs. I was like, you have to stop this. She was like, there's nothing we can do. And I was like, man, but yeah. And that's one thing I appreciate about, where we're at is the attorney support. Like anytime at WVU Medicine that I've had to go and testify, I've had amazing attorney support. They helped prepare me, and even there they prepared me and were involved. So.
Yeah. So that reminds me of the next topic I want to touch on, and that's subpoenas. Does everybody know what a subpoena is? So a subpoena, what it means is it's a paper that tells you that you must appear. That's all it means. You must appear. So you may get a subpoena in the mail, and it says that you need to appear at this courthouse on this date for this hearing about this person, and it'll have a name on it. Oftentimes they're brought in by process servers. So you're being served like you would serve someone like divorce papers or something. I often tell the courts, please don't just like fax it to me, just mail it to me. I do not want somebody telling me I'm served in the middle of the office building. But oftentimes they come through a process server. If you're at a bigger agency like WVU, if they come by mail, they often get sidetracked to legal, which is kind of the intention. As a forensic evaluator, I know that I'm up to testify on every case that I do, and so it doesn't really surprise me when I get a subpoena in the mail. Now, however, I got an email about being deposed in a clinical case, and that time my first call, and this should be everybody's first call when they see a subpoena, is to legal. If you have a legal department, call them. If you don't have a legal department, you probably want to have some sort of attorney that you can reach out to and consult about these types of cases, or even like your insurance. Some of the APA trust, I think they have attorneys that you can reach out to, and that's because you want to make sure that the subpoena is legitimate. And the worst thing you can do with a subpoena is ignore it. You cannot ignore a subpoena. You receive a subpoena, you have to respond to it. And that might be calling the attorney that is on the subpoena and saying, hey, I'm on vacation that week. Or in my case, a couple of times I've said, hey, I'm going to be on maternity leave, or I might be having a baby that day, so I can't testify. And at that point, they will probably work with you to find another time, or they have alternative ways of getting your testimony. But you've got to respond to the subpoena. But your first thing to do is make sure it is a legitimate subpoena. Especially if it was like asking to do for you to turn over records, that would be a lot more. You want to make sure that they have a right to receive those records. Laura, I think you had a question.
Yeah, so when you said make sure that the subpoena is legitimate, does that mean, I doubt it's this, but like that someone would fake it and it didn't go through the proper channels, or is it more to make sure that they have a right to ask for what they're at? Like, I guess in what way is it like most likely to be illegitimate?
So it might be the concern is that it was nefariously written by someone. But if you think about like a custody case, an attorney could send you a subpoena that says, I want all your therapy records on the mom in the custody case. It could be coming from dad's therapist or dad's attorney, and maybe it didn't go through the right channels in the court process and he doesn't have a right to see it. That would be like the nefarious big HIPAA violation concern. Other ones, that's what I would want to make sure about. But it always comes back to, you're going to break confidentiality because of this. Most likely. Now in forensic evaluations, they have no confidentiality. So that is, and they've been warned about that. But in most cases, when you're doing therapy, your patient expected you to keep confidentiality unless you've been ordered by the court to respond. And so going to legal is the first step. Like Amanda said, WVU's legal team is wonderful. They will prep you for your testimony. They will tell you, yes, this is legitimate. Actually, the legal department will respond about the subpoena for you. Like you may call them and just say, yeah, I can make it on this date. That's fine. When I was getting called to testify right before maternity leave, the legal department said, if we get that letter in the mail while you're out, we will respond and tell them you're unavailable. And this is when you would be available again. If you're working in other agencies, I would ask who you could speak to about the subpoena. I try to take the subpoena with me when I go to court, just so I can find the right courtroom and the right time. And it's happened before that I show up at the time on my subpoena, and actually it happened recently. The time on my subpoena was like 11 a.m. I then got a message the day before from the attorney that said, we'll see you at 9. And I was like, whoa, wait a second. My subpoena says 11, you're telling me 9, which is it? Turns out it was actually 9. So if I had shown up just based on my subpoena, I was going to be 2 hours late for this court proceedings. So following up with whoever subpoenaed you, I think is really important. Another distinction that I want to talk about today is the distinction between testimony and a deposition. Has anybody ever been deposed in this group? No, it's probably a good thing. They're challenging. They're challenging and pretty stressful. I will say I've only ever been deposed once, but I've always been much more fearful of depositions than I am about testifying in court. I think if you were testifying in an expert capacity, whether it's that you're an evaluator, or let's take Laura's specialty. She could be called, I'm not going to come up with a fake scenario because I'm not sure I could do it, but she could be called as an expert in bariatric surgery, in pre-surgical evaluations for bariatric patients. Say there was a bad outcome and there's a malpractice lawsuit. They may want her just to talk about what is the purpose of this pre-surgical evaluation, what is best practice of what to include in that evaluation, what shouldn't you include. So she's not actually going to be evaluating the person who got the surgery. She's not going to be evaluating the evaluation that's already occurred. Her role is simply to tell the court, this is what best practice is. And so that could be something. And those are kind of interesting and kind of fun experiences because you're the expert. They know nothing about any of this. And it's really your chance to be a teacher. And when I testify, I really try to put my teacher hat on and try to explain it in the way that I might explain it to undergraduate students or even graduate students about these different types of topics. But I'm going to backtrack to deposition versus testimony. So a deposition it's testimony under oath, but it's before you would get to a trial. So a deposition, in my world, this comes up more in civil cases. So if I'm doing a personal injury case based on oftentimes the diagnosis of PTSD after an accident or injury, they'll do a deposition and then they'll take the transcript of my deposition and they may have me testify 3 months later. And they want to know that my deposition and my testimony match up. And they're going to the other attorney's going to try to catch me changing my testimony in an attempt to discredit the evaluation. And so the deposition is going to come from usually the person opposite the opinion that you gave. So for example, if I'm hired by a defense attorney, if I'm hired by the attorney for the person who's filing the suit, then it'll be the defendant, it would be the other side, the person who's defending themselves against this lawsuit, who would depose me. And it usually it can occur by video, or it can occur in a room. It'll have both attorneys. The attorney that's on the side that's hired you, in a sense, the opposing attorney, and a court reporter. And so it's just like a courtroom without a judge and without lots of people watching. So the court reporter is going to write down everything that is said in that deposition and make it official for the record. And the hard part about depositions is that any question can be asked in that deposition. And if they were to ask an inappropriate question, like Amanda was talking about before, or even a personal question, like say it's a custody case, they could ask the evaluator, have you ever been divorced? And the hard part with the deposition is that the attorney may object. They may say objection. With a deposition, there's no judge there to rule on the objection. So the evaluator has to respond. Yes, I've been divorced 5 times. Now they can go into court and the judge will go through those objections and they can strike it from the record, but it can be uncomfortable for an evaluator. These would be, civil suits usually have a lot of money attached to them, and people get a little bit, it gets really intense when it comes to money for people. And so more high profile or higher stakes civil cases is when you would expect kind of that more difficult deposition. The deposition that I did was just a lot more specific questions. So they would say things like, how many times have you talked to the other attorney? What dates did you talk to that attorney? What did you talk about with that attorney? And I was like, honestly, I've talked to this attorney on the phone probably 15 times, 5 to 10 minutes each time, and I don't remember the context of the conversation. As a good evaluator, I probably should have had all of that documented. But so there sometimes can be difficult questions there. So that is it. Yeah.
So you have to answer in the deposition, but if you don't, go ahead.
I should clarify that. You have to answer if you know the answer. Your answer could be, I don't know that. I don't know the answer. I don't recall. I didn't assess that, but you have to give something verbally back.
So if it's something that you know, but don't want to say, like your example, if it's like, how many times you've been divorced? Do you just have to give an answer even if you don't want to?
Yeah, kind of.
Interesting.
I mean, I guess you could say, I wish not to discuss my personal relationships. But then if he asks again, they may just finally tell you, just give him an answer.
So that's why Elizabeth Holmes just kept saying, I don't recall. Right? Is that the best answer?
Probably. Yes, that's the best answer. And if you really don't recall, it's even better, but yeah, that's the best answer. Do I have anything in the chat? No. So let's walk through what it would be like to testify in either a bench trial, which means it's just the judge, or in a jury trial. It would, the testimony would start, let's go with an expert witness. So the testimony is going to start with a process called voir dire, which is Latin words that are always hard. I'm going to I'll write the Latin in the chat for you. This is also the same title of the process they used to pick a jury, so don't get confused there. But a voir dire for an expert witness is the time that the person who is calling you to testify gets to lay out your credentials. Why should you be qualified? And to lay out those credentials, you tell that they're going to ask you questions about your training, your knowledge, and your experience in the particular area in which you would testify. That was why I asked Jason in the beginning, did they qualify you as an expert in psychology? Because that's a little bit different than qualifying him as an expert in forensic psychology or health psychology. Are you an expert in bariatric evaluation? So it may be very specific area in which they want to qualify you. The questions they'll ask are things like, tell me about your education. So you can go through undergrad, grad school, PhD, internship, postdoc, whatever your training experience is. Have you ever evaluated a person for this same type of evaluation before? Have you ever completed a competency evaluation before? No, I have not. Yes, I've completed approximately 300 competency evaluations. They often ask, have you ever been qualified as an expert before? If you say yes to being qualified as an expert in West Virginia, oftentimes they'll say, okay, she's qualified, move on. But in a bigger case, or they don't know you, they'll go through, where are you working now? What is your job? What clinical experiences have you had in the past? They may go into like, what publications have you had? And it just kind of, again, solidifies that knowledge. And then the experiences that you've previously given. And then at the end of that, so if the defense called you to testify, at the end of that, the prosecution can get up and they can also ask you questions about your experience, knowledge, and training. And of course, theirs are going to be, for a psychologist, their first question is usually, so doctor, when did you graduate from medical school? And we say, I didn't graduate from medical school. I'm a psychologist. So you can't prescribe medication and you're not a psychiatrist? No, I'm not a psychiatrist. And they try to kind of trip you up that, they're trying to discredit that you were just a psychologist, just X provider, rather than the provider that they believe has more credibility. And then at the end of that, the judge gets to decide. And so at the end, they'll say, Your Honor, I move to qualify Dr. Lillard as an expert in forensic psychology. And the judge decides, and he can say yes or no. I've only ever heard of judges really saying no to qualifying an expert when it's a trainee. And they understand you have to have a first evaluation in order to have experience in evaluations, right? That comes with experience, but sometimes they feel that people aren't qualified enough as trainees to be experts. And so that can be an issue. It also could be if the cross-examination really demonstrates that you have no experience in this before, they could discredit you. What would happen then is that you would become not an expert witness, but a fact witness. So you could talk about your report that's been written, but you could only talk about what you observed, behavioral observations, even your diagnosis, their history that they gave you, but you would have to stop before giving an opinion. So you wouldn't be able to say, therefore, Your Honor, I believe this person is competent to stand trial, or I believe this person is fit to be a parent. You couldn't give that opinion if they did not qualify you. 9 times out of 10, they'll qualify you. Then say the defense attorney called you to testify, you would then be asked what's called direct examination questions. This is the easy part. This is the part you've been prepped for. You may have questions given to you to prepare. This is the part where they often would just go through your report or the documents that you've given them. And this is the part where you'll be asked open-ended questions. Doctor, did you evaluate this person? You'll say yes or no. And then they'll say, tell me about what information you used to come to this decision. You're like, well, I interviewed this person, I talked to their mom, I talked to the dad, I talked to the social worker, I reviewed these records, and I did a clinical interview and psychological testing. So you'll just kind of go through everything that you've done. They're going to be, this is your chance to kind of talk. They're going to let you just kind of expand upon your expertise, talk about the information given. When that's finished, it's then time for the cross-examination, when the prosecutor in our case, in our example, comes up, and they're going to ask you very direct yes or no questions. They want to pigeonhole you into saying just yes or no, and they want to pigeonhole you in a certain direction usually. And so a good cross-examination is very fast-paced. They're just trying to get you to answer without really kind of slowing it down to think. So my advice to everyone when it comes to testifying is to watch the pace. You, as the person testifying, can control the pace of the questions. You can control it by taking a deep breath before responding. You can control it in the pace of your responses to them. You can control it. What I often have to do, especially a really long question, I'll say, I'm really sorry, could you repeat that question? It gives me more time to think about my response, and it slows it all down. And so just be very careful that they're not getting you kind of tripped up, because they're speeding up the process in a cross-examination. These are the questions that you can't really prepare for, although if you have a colleague who's been in a similar situation, yes, Laura, you can get really caught up in mirroring the other, the attorney. So you don't often get to prep for cross-examination. What you get to do is you could talk to colleagues who've been there and have them give you some feedback. I had a colleague here who was fantastic at this. I give her my report. She would tell me, these are what they're going to ask you in testimony. And I was like, I don't know the answer to these questions. They're really hard. I was like, there's no way. There's no way these are the questions that I'm going to get asked. And I ignored her feedback. And wouldn't you know, I got asked those questions on the stand, and I did not have a well-prepared answer because they were very difficult questions. And so trusted colleagues are always good. You know, if you were to get subpoenaed or you wanted some feedback about what to prepare types of questions, that would be a great case example that you could submit to Elizabeth, and maybe we could talk about it in here, de-identified, of course. But and you could, I mean, you can give me a call if you want to talk about kind of how to proceed or what to do in those cases. But consulting with others is really helpful when it comes to those cases. So that was a whirlwind. We kind of covered expert witness testimony, fact witness testimony, depositions, subpoenas, questions.
While you think of some questions, that was really great involvement in the chat. And thank you so much for being on the fly, Dr. Lillard. I think you did great. And it did make it very interactive. So
yeah, maybe I need to stop PowerPoints from now on.
So that's really great. Does anybody have any comments or questions that they haven't had a chance to do?
I guess I'm wondering, as someone who's not yet had any of these experiences, and I acknowledge that it's likely that in my long career, it'll come up at some point. I could see how it would be very stressful and upsetting. I wonder what some of the biggest fears are as someone who gets called to be, I guess, as a fact witness, what are some of the biggest threats to a fact witness of worst outcome? Like, is it, I'm worried I'm going to lose my license? Or is it, I guess I wonder, since I don't have experience knowing that people get very stressed, is it just the in the moment experience, or is it long-term consequences about losing your job or being charged with criminal charges, or like, I just don't understand.
I think it depends. If it was your clinical work that was being questioned, that would be entirely different and very stressful. I think it's, for some people, it's the idea of presenting in front of others. I think some of it, at least in my mind, some of it comes to like, I want to seem knowledgeable. I want to seem credible. I want to continue working in this field and people to refer cases to me. And I don't want to be embarrassed, you know? And I think that for me, embarrassment would come from not eloquently answering questions or having absolutely no idea how to answer a question. And I'll give you an example. Imagine being asked on the stand to define a delusion. What would you say? This isn't the tricky part. So I was asked on the stand one time to define a delusion. I said a false fixed belief that remains despite contradicting evidence. Okay. Then the person read to me another definition of a delusion, and it was similar. And he said, "Is this accurate?" And I was like, "Sure, yeah, that's the same thing." He then said to me, "Well, you noted this person has a lack of insight into their diagnosis of schizophrenia. Isn't lack of insight a delusion?" We have a whole bunch of psychologists on this call. Somebody tell me how you explain that lack of insight into a diagnosis is not delusional.
So I'm guessing in that circumstance, like you didn't think that they were similar, but you had to then explain how they're different.
So what he was trying to do is make the claim that I said that he had schizophrenia in remission. He was no longer experiencing hallucinations or delusions, but he still had a lack of insight, or I said partial remission. And he was trying to make the claim that he was still psychotic and delusional because he lacked insight into his mental illness. And it was an attorney, and they twist the words around, and they're very good with kind of mind games and word games. That's what kind of makes a good attorney. But that's the example that sticks to me, that I had no idea what to say. I knew the answer was no. They're not the same thing, but I could not tell him why. I still don't have a really good answer. But
well, thanks for the example.
Yeah. So, and so I think at the end, the other hard part is that it's really hard not to take our work personally. And so it's hard not to attribute someone in this case is going to be trying to find holes in your work. And it's very hard not to internalize those holes that they're poking is just what they do. That's what attorneys do. They just poke holes in everything. But I think at least for me, I find it sometimes really hard to not think that they're poking holes in my abilities and in how good of a provider I am. So if this cross-examination really kind of destroyed or set it up to sound like I didn't do an adequate job as a therapist, I would take that really hard. So I think that's the fear, and just the unknown. This is a new situation. This is legal stuff. I don't understand legal stuff. I don't understand judges. I don't understand attorneys. Leave me be in my practice. I think that also can be a problem. I don't think it's often long-term ramifications. I think it's short-term, like social anxiety type concerns. Anyone else want to talk about what might make them fearful about testifying?
I always worry about my paperwork. Like, I always wonder if I put too much in there, too little. And if I put too little, or I say, don't recall, they're like, I want you to think back to that session and tell us what you can recall of it. And I'm like, well, like, So I always worry about my documentation and it always, I mean, it always aligns, and you're right. They do poke holes where they can, but I think I just worry because, sometimes I feel like I put too much and they do twist things. And then sometimes I want to make sure I put enough so that I can recall in their defense. So it's hard.
One time in a report, this person had been evaluated 50 times. And I said, social history will not be repeated here as it's consistent with previous reports. Well, then they started asking me questions about his social history. Again, I saw this guy months ago, and now they're saying, so how far did he go in school? And I'm like, I don't know, because I didn't put it in. Now I always put that kind of stuff in because I don't want to forget it.
Yeah.
The other thing I heard Amanda say earlier, it was kind of the fear of her relationship with the patient after the testimony, based on the things that you were kind of compelled to say in the courtroom. And there's one other thing I wanted to talk on, and that's that when you first get on the stand in the court, when you walk into the courtroom, I always try to sit on the side behind the attorney that's called me, if I can figure out who they are. And then my first thing that I do is I find the quickest, best route to the witness stand, because every courtroom is different. And so I would sit down and I figure out, okay, I'm going to walk straight through those, and then I'm going to go around this podium so I can get there and I don't look silly trying to get onto the witness stand. And the next step when I get onto the witness stand is that a bailiff is going to come over and they're going to say, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? And you say, yes. You are now under oath. If you misspeak here, you can be held liable under perjury for misspeaking. And I think that's another place of anxiety for people. I know for me, I'm always like, I think this is what happened, but I'm not sure. I think this is where Amanda was like, I don't want to go back and think about a session. What if I misspeak? What if I don't tell the truth there? The other thought I want everyone to kind of think about, one time I was testifying, I got up to the stand, I went to put my right hand up, and a Bible was pushed in front of me. And they said, please put your left hand on the Bible, raise your right hand. And I didn't have any time to like comprehend that, oh, they're serious. The Bible is there. I was not in rural West Virginia. I was in Cabell County. I was in Huntington. And I was asked to put my hand on a Bible, swear to tell the whole truth, nothing but the truth. My beliefs are such that that was okay with me. Swearing on a Bible was okay. If that is not a belief that individuals agree with, if it makes you really uncomfortable, if you would be unwilling to swear on a Bible, I would encourage you to come up with a response to that, and come up with it before, so that, because there was no thinking time when I walked onto that stand. I had no idea a Bible would be pushed in front of me. But I do know that that doesn't align with certain people's beliefs. And I think that that probably would have been okay if I'd had something kind of already planned. Your Honor, I swear I will take the oath, but I prefer not to put my hand on a Bible. Or, Your Honor, I've brought with me a book that I would rather take my oath on. I bet those would be accepted and fine in most cases, but I think that it's something most people don't tell you to be prepared for. And so if you have a very strong feeling against that, I encourage you to come up with a statement, because I was like totally caught off guard.
Colleen, one of the things I wanted to share too, and I don't know if this is true in West Virginia, but I know when I worked in PA and I had to testify, one of the attorneys prepared me at one point, and she said, she said, if you get up there and you say, they ask you questions about the case and you say, I can't share that information unless I'm ordered to do so. She said, even though you're ordered in the subpoena, she said, unless the judge orders you, you don't have to. And I got out of a couple cases that way because the judge was like, oh, she can't share it. Like, he didn't even want to be bothered with it.
That's a really great point, Amanda. Your subpoena is that you are required to appear. You are required to walk into that courtroom. That is as far as that subpoena goes. You are not required to say things or act against your beliefs. You are just required to appear. Thank you. One other thing, sorry, I'm like catching all my tidbits. Anything that you bring onto the stand with you can be put into evidence. Anything you bring onto the stand with you can be put into evidence. Apparently, if it's in a briefcase and the briefcase is closed, they cannot take things out of your briefcase. But if it's out in the open, like if you take so I'm saying this, don't take their file with you. If you do, leave it on, like leave it at the benches back there. Don't ever pull a file out and put it on the stand, because they can take that whole file and they can put it into records, and now it's public information. What I take with me to court, I take my CV, clean copy, nothing written on it. I take a clean copy, no notes, nothing written on it, of the report. And sometimes I do a one-page summary of my report. So where I write out diagnosis, opinions, meds, just things so I can look down in one place and respond without having to flip through my report. But it's everything on that piece of paper is also in my report. So I don't care if it gets put into evidence. And sometimes they won't have your CV. So they sometimes will take your clean copy and put it into evidence. So only bring onto the stand what you are willing for them to put into evidence.
Thank you so much. Jason, I saw you unmuted. Did you want to make another comment or have a question?
Yeah, question. If we're compelled to testify, regarding privileged information from therapy sessions, but the patient doesn't give permission for that, but then the judge orders us to offer testimony about that.
My advice would be to try to stop it, right? I'm not privileged to give that information. Like respond in a way that indicates you're trying to hold your patient's information private. If the judge orders you under contempt of court to state that information, I'm not going to jail for a patient, right? I'm just not. At that point, I would share, and I think you'd have enough evidence to say, look, I tried to keep it privileged. I was compelled under threat of contempt of court to make this statement, and then I made it. And
and that would be enough for an ethics board if it went under review?
I think so, because I think you're doing it in good faith.
Right.
I think, although I'm also the person that believes that the Tarasoff case was wrong and that they did the right thing in their duty to warn, and the psychologist should not have been sued. They called law enforcement messed up. It's not on us. But I clearly was not running California's Supreme Court when they made that decision. So, but I think that's all you can do. If the judge is that adamant that you make that statement or you're going to jail, I'm not going to jail.
Would it be appropriate to ask the court to confer with your patient one more time, before?
They also sign those HIPAA releases. And I think part of the HIPAA release is that if they bring their mental health into the courtroom, you're free to talk about it. So that would also play into it a little bit. Did they bring the mental health issue up to the court? Like if it was personal injury, you were doing therapy, but it's a personal injury case, they've already brought up their mental health. So they've already kind of consented to that being brought into the courtroom. I imagine with kids, it's going to get trickier. I don't know how that all would get handled. I think I probably would be like, I'm really uncomfortable stating this information because I believe that it's privileged between me and this client. And I think I would just kind of try to repeat that until I was threatened with contempt, and then I probably would just testify.
Okay, thank you.
Thank you. Thank you so much, and great discussion. Thank you so much, Dr. Lillard.